Good evening, students. Welcome to CredenceLaw Learning. Today's discussion is about parts of statute. Parts of statute. Every time when the judges are interpreting the law, they always use certain interpretative principles, certain aids to understand the legislative intents. Words are sometimes unclear and confusing. To help understand what the law really means, the judges use special tools. They are called as aids of interpretation. Help to understand the law enacted by the parliament is aid to interpretation. This also help judges figure out what the law makers actually intending to say. So internal aids of interpretation of statutes are the tools that exist within the statute itself. That is why it is called as parts of statute, which is very important to understand the intention behind making the law. And these are the certain internal aids, which are also called as parts of statute. And mm, first, it is here short title, long title, preamble, marginal notes, punctuations, illustrations, definition clause, proviso, explanation, schedules, transitional provisions, exceptions, articles. These are the parts of statutes which are called as internal aids because these are the parts, these are the helps, that is aids which are available within the statute itself. First, we do have here is long title and the short title. Now, when we talk about long title to an act is the part of the act and it is admissible as an aid of interpretation. Long title, like preamble, is a good guide regarding the object, scope, and purpose of the act. And here, long title usually starts with the term an act. An act. Example, we can speak of CPC, wherein CPC the long title is an act to consolidate and amend the laws relating to procedure of Court of Civil Judicature. That's the long title. It was in Kerala Education Bill. The Code of Law said the Supreme Court emphasized the policy and purpose can be understood from the long title and the preamble of the Act. And in the Mohanlal versus State of Punjab, long title was considered to be a guide to decide the scope of the statute. These are the two case studies pertaining to long title. Then we have short title. Short title of an act can be said to be a nickname of the act. It is only an abbreviation for the purpose of reference. It is not useful aid of construction. It is just the abbreviation. Then comes the preamble. The second important aid of interpretation is preamble. Preamble is something which summarizes the primary goal of the legislation, the intent behind making the legislation. It is helpful to interpret the enactment, the statute. It is like key to open the minds of the maker. It is the gist of entire statute. The main object of preamble is to emphasize about the object of the act, and preamble is the gist, nutshell of entire act. And here, if the Okay, the case study Kashi Prasad versus State, the court emphasized even though the preamble cannot be used to defeat the enacting clause of the statute, it can be used, it can be treated as a key to interpret, key to understand the statute. So that is why it is called as key to open the minds of the maker. We also have the preamble which says, "We, the people of India, having solemnly resolved to constitute India into sovereign, socialist, secular, democratic republic," and the preamble of Constitution strives to secure to its people justice, liberty, equality, fraternity. So this is the preamble of the Constitution. So preamble of the Constitution is, it is talking about the object of entire Constitution. That is the second internal aid. First is long title, short title, preamble, and then marginal notes. Marginal notes are the notes which are inserted at the side of the sections in an act. It expresses the effect of the section. So marginal notes are the notes which are inserted at the side of the section, and it expresses the effect of the section. They are not the part of the provision. They cannot be considered as legitimate aid, but still it is not determinative to avoid it completely. And the case Bengal Immunity Company was a state of Bihar, where marginal notes of Article 286 of Constitution was considered and was considered to be useful for its understanding. And then Wilkes is a Goodwin case where the court said side notes are not the part, so it is not to be considered. So one case study is emphasizing on its importance. The other case study is ignoring its importance. So marginal notes gives the brief along with the statutes section. It is something which is given in the side, inserted in the side of the section. Then we have punctuation. Punctuation are the internal aids, though they are minor, but still they are very useful in proper interpretation of the statute. Punctuations, though they are the very minor elements, but they are to be considered to understand the purpose of the enactment. Sambhunath Sarkar versus State of West Bengal case, and then illustration. Examples. Illustrations attached to the statute is very important aid of interpretation. It is helpful to understand the section in a very proper sense. Sometimes illustrations attached to the sections helps to better understand the concept. So illustration are also internal aid of interpretation of statute. Then illustration to the sections at the part of section and helps to elucidate the principle of the section, to understand the principle of the section. And this is just a quick information about the notes classes available. If you are in need of notes classes guidance, you can contact to the number given. Then we have definition clause. Many laws in its statutes define certain terminologies. Majority of the statutes contains the definition clause in its section 2. Mostly in the section 2 we find the definition clause. The definition clause helps here the words and expressions used anywhere in the statute or commonly defined in the definition clause. The object of such a definition is to avoid the necessity of frequent repetition of describing all the subject matter. Here, it is to avoid the repetition of the same thing. Definition clauses inserted to better understand the terminology which is often used in the statute. That is usually found in clause 2. Proviso is which creates exemption to the main rule. Proviso is something which creates exception to the main rule. Union of India, usually the proviso starts with provided that. So we have the case Union of India versus Sanjay Kumar Jain, where the court explained that provisos qualify the main. It creates exemptions to the main provision. And then we have explanation. Explanation is something which elaborates the meaning. Explanation is something which is added to the section, it elaborates the meaning. And explanation are considered to be the part of the section, are to be read together. Then it is schedules. These are the details which are attached at the end of the law. We usually find schedules attached to the main law, and schedules are also the parts of statute. Since it is attached in the statute itself, it is attached after the main law. Then transitional provision. It's a temporary provision. It's a statutory provision which provides guidelines when the old law is being changed into the new law, and for its smooth change. And it's a transitional is a temporary provision in most of the cases. And then this exceptions, there are certain laws which create exceptions to the main text. So we have certain laws which gives exceptions. So here, exceptions, notification, exception there too is what we usually come across in the act. Exception is that is something which gives exceptions to the main enactment, something which is exempted from the main enactment. And then there are certain other internal aid parts of statute, articles, and yeah, this is all about the internal aids. Internal aids, short title, long title, preamble, marginal notes, punctuation, illustration, definition clause, proviso, explanation, schedules, transitional provisions, and exceptions. And um, internal aids, which are also called as parts of statutes, are very essential tools for the judges to better understand the law. And it is an aid, it is a help which helps the judges to properly understand the terminology used, examples mentioned, provisions created. By this internal aids, courts can discover what the legislature is intending to enact. So that is the importance of the internal aids. As we all know, there are three organs to the government: legislative, executive, and judiciary. When legislative is enacting the law, legislative is not influenced by other two organs. So, when legislative is the organ which is going to enact the law, the same is going to be interpreted by the judicial organ, which is altogether a very different body. So, at that point of time, what happens? The judges need to apply certain principles, certain aids to be used to come to a proper conclusion of the statute and apply it to a given case. So here, this internal aids is very helpful for the judges to better understand the true intent behind making the statute. All the best for your upcoming exams. If you have any queries, you can contact to our team. See you all in the next video.